viewers and listeners, welcome back to Mind Your Business. My name is Joseph Mwenda, and on today's episode, I'm so humbled to sit down with a man who I consider, I think, one in the top 3 of the most influential people in the justice system in Zambia. You can't go to court for any criminal offense unless the office of the Director of Public Prosecutions under the National Prosecutions Authority has sanctioned that case. And I'm sitting down with a man who, on behalf of the state, checks to see if the offense you have been charged with has all the legal ingredients to stand in court. Help me welcome the Director of Public Prosecutions, Mr. Gilbert Phiri, State Counsel.
Thank you so much, Mr. Mwenda. Thank you so much. I'm honored to be here.
Thank you. Sometimes when you hold such a powerful and influential position in government, sometimes people think you were born with that kind of power. I want to just get to understand who is Gilbert Phiri before you get the conviction of saying, I think I want to take law as my career.
Indeed. Thank you so much. I have been in practice now for around about 18 years.
Right.
And I've worked in private practice as a lawyer. I've managed a law firm. And also, before then, I started officially my work career in the banking sector.
Okay.
And then, of course, I have a teaching background.
Oh, interesting.
I really enjoyed teaching. I miss it.
Right.
And I hope that towards the end of my career, I might return to teaching. But yes, that's my background.
Right.
After private practice, I transitioned and became Director General of the Anti-Corruption Commission.
And maybe before we go to the Director General for ACC, yes. What was the conviction that got you to say, I think law for me? Why quit teaching?
Yes. First of all, teaching was a very enjoyable career for me. I really enjoyed it.
Right.
And of course, I rose to be head of department. I became a lead at a young age.
Right.
And I felt I'd achieved a lot in a short space of time in my career. And I felt I needed a different challenge. But even though I did teaching, I'd always wanted to be a lawyer.
Right. Okay.
Yeah, I'd always wanted to be a lawyer, and I've always wanted to stand up for anyone being abused, any underdog.
Right.
It's like something which is latent within me. But funny enough also, when growing up, one of my neighbors was a very smart man.
Okay.
Extremely, the exterior, he was extremely smart.
Oh.
And I later found out that, in fact, he was a lawyer. And because of that,
I see.
I wanted to be a lawyer. Without knowing the nitty-gritties of what a lawyer did.
Right.
And, of course, later on in school, to find out what it involved.
Right.
But unfortunately, when it came to filling out forms to go to the university, I think we're misled a bit, but it's water under the bridge. But then I went into education, which I thoroughly enjoyed.
I see.
And the skills that I acquired from teaching are the skills that I started using in the courtroom.
Okay.
And I still use in my work.
Right.
You know, teaching involves critical thinking.
Right.
It involves vocating.
Right.
Articulation. And ensuring that people understand. You must ensure that you bring people to a point of understanding, persuade them to a certain viewpoint.
Right.
All those skills.
Right.
It's one and the same thing.
I'm happy earlier you say that from childhood you were not happy to see someone being abused unfairly, and you thought, you know what, I think I would want to stand up to, to such instances. And I know you are one of the people who, or counsel who actually worked very hard in making sure that the current president actually is assisted from a legal front during his opposition years. To me personally, it wasn't very surprising when I noticed that you were appointed Director General of the Anti-Corruption Commission. But immediately, that appointment threw you into a very critical role of watchdog against your former client and all other people who have actually served in government. How did that make you feel?
Well, I didn't. That was a good thing for me. I mean, because I knew the remit of the job that I'd taken on. We had to fight corruption.
Right.
And do so ruthlessly. And I think the tone was set from the top.
Right.
And even before I joined public service, there had been serious pronouncements on no sacred cows and fighting corruption. Because in any event, any government that runs for public office, they do so on the strength of them coming to fight corruption. That's one of the major things they promise the people. And therefore, it means that all government institutions must be aligned towards that goal. So when it came for me to go to Anti-Corruption Commission, I knew from day one exactly what I needed to do. I did not need anyone to tell me what I needed to do.
Right.
So from day one, we set out, first of all, to transforming the institution.
Right.
Because it had a checkered past. A few things had gone wrong in the institution. So we needed to rejig it, revamp it, reposition it, retool it, and rally the forces to fight corruption. But I was not mistaken about what I needed to do. We needed to go for people that had stolen from this country.
Right.
And at the same time, there were no sacred cows. Whether one was in government or not in government, they had served in government or not served in government, we went as long as there was a prosecutable case of corruption and one that had all the ingredients. It's a matter that we took either to court or ensured that we followed all lines of investigation. We did not look at a case and look the other side simply because it involved someone in government.
Right.
We did not do that.
Yeah, and it would be easy. Someone might actually say that, because of the work you did prior to the UPND, winning elections in 2021, perhaps this was a reward for you. You did a lot of work. What do you say to that insinuation?
That I don't think so. That it was a reward, I don't think so. Of course, only the appointing authority, of course, knows on what an appointment is based on.
Right.
However, the appointing authority knows my capabilities.
Right.
Senior members of government, they know what we are able to bring to the table.
Right.
We may not be the best, okay? However, there are certain principles that we hold sacrosanct in whatever we do.
Right.
And I think there was a realization, or there must have been a realization, that we could execute what was required to be executed within the anti-corruption space. Because we had been doing this work even before coming into government. In court, we're taking up cases that others could not take up.
Privately?
In private practice.
Right.
Yes. Yeah. And I was also involved in private prosecutions.
That's what I was referring to.
Numerous private prosecutions.
Okay.
On the right side of the law.
Okay.
And in most cases, we secured either convictions, and when we were on the defense side, we secured almost near 100% acquittals.
Right.
So we had been in the, for lack of a better word, we had been in the game for some time.
Right.
That's what we're known for. We're known for defending the right things.
Exactly.
And when we were brought to public service, we knew what it was that we needed to do.
I hear you. What was the highlight of your period at the Anti-Corruption Commission? What is something that comes to your mind to say that period, whether it was very difficult or it was a more successful period, or something that you remember that you carry with you during your time at the Anti-Corruption Commission? Yeah,
I know it sounded, it feels like it was a very long period of time. I was only there for 6 months.
6 months, ne?
6 months.
Right.
But I think that 6 months, it was like a house on fire. What I recall is that there was a lot of spotlight on whatever we did.
Okay.
But we also resolved that whatever we did, we needed to communicate it to the public. We needed to carry the public along with us.
Right.
So we revamped our social media platforms, and we ensured that we were more in communication with the people.
Right.
Mr. Timothy Mono, our spokesperson, was more in communication with the public. And we ensured that we publicize even cases that were coming up.
Right.
We carried the public along. I may not point at one highlight, but we went for all those known cases of corruption. We went for them.
Right.
But we made sure that we first of all, we looked at the members of staff that we had.
Okay.
And looked at how we could deploy them. You know, when you're trying to deal with something, we're looking at who are the sharpest tools that we have in the toolbox.
Exactly. Yeah.
And where can we deploy them to ensure that we attain the result that we want.
Okay.
So we looked at the entire staff. We moved the pieces around, and we lobbied government for support. And true to form, government came to the party and were given money. We ensured that we bought vehicles for the institution, computers, furniture, motivated the staff a bit. That remains with me.
That was within just the 6 months that you were there.
Just within the 6 months.
Oh, wow. Interesting.
And we could see the goodwill from government, that indeed government, the treasury part of government, meant business. You know, everything was resonating. We were all aligned.
Right.
That I knew as head of the institution that we were focused on fighting corruption. We also had a terrific board in place that was put in place that we worked very well with. We were in agreement with where we're taking the institution.
Right.
And things worked well. It was a short period of time, but I think that we cannot say that we had convictions. However, the very fact that we brought a lot of issues to the attention of the public and sustained the public's interest in what we're doing, for me, that is extremely important. But also brought in our cooperating partners into this fight and also to support what we're doing. We engaged them more.
Okay.
To me, those were the highlights.
Then you get the appointment to move to the National Prosecution Authority. I would like you to help my colleagues, the viewers, understand your mandate, helping the public to understand your mandate in terms of what you can do and what you cannot do as Director of Public Prosecutions.
Yes. So the Director of Public Prosecutions mandate is drawn from the Constitution. Article 180 of the Constitution makes the Director of Public Prosecution the head of the National Prosecution Authority, the chief prosecutor of government, under the National Prosecution Authority Act, the chief legal advisor on all criminal matters, the Minister of Justice. So essentially, when it comes to all matters to deal with criminal law, my office is the arm of government that advises and leads in that respect. So according to Article 180 of the Constitution, the role of the Director of Public Prosecution is laid out. You initiate criminal prosecutions. If someone else has initiated criminal prosecutions, we can take over and continue those criminal prosecutions and discontinue where need be. So anything, in simple terms, to do with criminal matters, initiation, continuation, discontinuous, is reposed in the hands of the Director of Public Prosecution.
Right. And now your case is very interesting because you've served at the Anti-Corruption Commission and now Director of Public Prosecutions. It makes it puts you in a position where you understand some of the loopholes which comes with investigation and making your work either easy or difficult as Director of Public Prosecutions. What are some of the loopholes that you think exist with the law enforcement agencies with regards to your work as Director of Public Prosecutions?
Yes. Now, first of all, to start with the fact that I worked at Anti-Corruption Commission and now I'm the Director of Public Prosecution. One thing that I realized when I was at ACC was the need to deal expeditiously when the Anti-Corruption Commission requests for the consent of the DPP.
Okay.
My office is required to give consent in certain instances.
Right.
And it's important that that is done, not hurriedly,
Okay.
but expeditiously,
Okay.
so that then the Anti-Corruption Commission can move on to prosecute that case. Because also the Anti-Corruption Commission prosecutes cases on behalf of the Director of Public Prosecution regarding corruption matters.
Yeah, and I want you to clarify there. Can they expressly proceed to prosecute without your consent?
In certain minor cases.
Okay, right. So they have a pre-approved mandate to go ahead and prosecute from
but
the
whatever
office.
they do, as long as it's prosecution, it's because they've been allowed to do so.
Right.
All prosecution, the Constitution is very clear. All prosecution is reposed in the office of the Director of Public Prosecutions.
Right.
So you find, for example, Zambia Revenue Authority prosecutes cases on issues of tax evasion.
Right.
The same as the National Pension Scheme Authority, matters to do with pension, workmen's compensation, and these others. There's prosecutorial mandate that is extended to them.
Okay.
Even local government authorities, the 116 municipalities, do prosecute under the Public Health and Local Government Act.
Right.
They prosecute matters on behalf of the Director of Public Prosecutions, largely for convenience.
Right.
And also specialization.
I thought so.
Like on tax matters. But for going back to the question you had asked.
Loopholes. What are some of the challenges that you noticed?
Yes. Different challenges do exist. But having had that experience of the knowledge of how anti-corruption works and the need to ensure that these matters timeously are taken to court, sitting on the other side, I ensure that we expeditiously work on the request by Anti-Corruption Commission on their dockets and ensure that either consents are given or they are guided in filling in the loopholes. Now, when you talk about loopholes, you know, at the heart of the work that we do as prosecutors and investigators, integrity is a key thing.
Okay.
Now, you see, we cannot vouch for everyone's integrity because a law enforcement officer, can be police, can be an officer from Drug Enforcement Commission or Anti-Corruption Commission or any, they're supposed to be people of integrity.
Okay.
They are supposed to investigate these cases and ensure that they do not leave out anything.
Right.
Now, of course, if they leave out anything and the docket comes to my office, we are going to spot it because my office ensures that we take bankable cases to court.
Right.
Cases that are prosecutable. Cases that meet the threshold of evidence. They must pass the evidential test. Is there adequate evidence aligned to this case that can stand the cold light of scrutiny in a court of law?
Right.
To us, that's extremely important. We look also at public interest. So there are public interest considerations.
Okay.
Is prosecuting this case in public interest?
Okay.
Okay. Someone has stolen a sweet worth 5 kwacha. Should I be in court for 1 year prosecuting that case? Is there public interest in that case? Which is why some of the cases that come, when we see that they are not of serious public interest, we advise the law enforcement agencies what needs to be done.
Okay.
Or I'll direct what should be done. So that we only go for those cases that there's clear evidence or evidence that meets that threshold.
Right.
And we leave it to the court to decide, but there's also public interest. So at the heart of everything is integrity.
Right.
The investigator must work with integrity and ensure that they do not bring a docket that is completely out of range and not fully baked.
Right. And I'm glad you raised that point. And now I need to understand from your perspective, where do you think is a challenge? Is it lack of training, lack of skill, or a pure case of lack of integrity, where a police officer is perhaps compromised, or they're just lazy, they don't want to do their job, or when I say the police, I mean everyone else in the law enforcement agency wings. Do you see it to be a challenge as an issue of education, skill, training, or just lack of integrity where somebody's just compromised? Maybe they've taken something and they don't want to do a good job, and they're pushing the DPP to move in the same direction as they are.
The challenges are legion. You know, one of the biggest challenges for law enforcement agencies is time. They only have a certain period of time within which to work.
Right.
There will be certain cases that will happen, you know, and they will not take 2-3 years investigating that case. They will work on it because there's public interest. I'll give an example of the case that recently happened in Kalumbila.
Right.
You cannot take 5 years investigating that case where there's serious public interest. So there's a lot of pressure on the law enforcement agents to ensure that people are brought to book. There are victims, there are families that have lost loved ones. So there's always this pressure on the law enforcement agencies. And within the limitations of resources, monetary and human, they have to work within a certain period of time because of this public interest to ensure that these matters are brought to court. And dockets are brought to my office.
Right.
And I may notice that a few things have been left out and send it back. There'll be back and forth. There'll be a bit of a loss of time. And the public out there will think that the job is not being done. But largely it's due to the pressure, a lot of pressure on these law enforcement agencies. But I also mentioned issues of resources, human resource itself, but also equipment. Training is also another aspect. You know, crime is dynamic. It evolves. In fact, criminals are way, way ahead. They're innovating on a daily basis. How do you keep pace with them? By building capacity in law enforcement. Now, you build capacity, you have to put resources to ensure that your forces are up to date. And here it's not just police, it's drug enforcement, anti-corruption, and the rest of the law enforcement agencies, Department of National Park, Wildlife, Forestry, and all these. But all this requires resources. And you know the proverbial issue of the limited resource envelope. So we have these challenges. There are so many of these challenges.
And I also want you to speak to the other challenge which I feel might be frustrating you, witness management. Are you, before you answer this question, to what extent are you involved in investigations as the Office of the Director of Public Prosecutions at all?
Yes, so we believe in prosecutor-guided investigations. In fact, that's the norm worldwide. Prosecutor-guided investigations. We give the legal direction to investigations. The technicalities of the investigation is a forte, or it's within the realm of the law enforcement agencies. However, we guide.
But that means, go ahead.
We do not do the actual investigation. But we give the legal guidance that should underpin these investigations. So when a docket comes, we are able to tell that a few things have been left out. And we advise, go and look at these things that have been left out.
Do you have access to law enforcement agencies at a point when the investigation is ongoing and an arrest has not been done, for you to be able to assist in terms of which direction they could take, perhaps, because you are saying guided investigations? How do you manage that?
You see, in the initial stages, the law enforcement agencies work out the investigations. You know, they will effect arrests, they will apprehend, and they will do the investigations. And depending on the type of case, they may interact with our office after they've done the groundwork. And we look at what they bring to us, and we advise how they need to improve, and whether certain individuals need to be added or removed. We offer that guidance. Because it's important when you're taking these cases to court.
Right.
So we do interact, yes,
right,
with law enforcement.
And I'm glad you say that, because this brings now to my question of, it could be frustrating where you've given guidance and the time the docket comes, you have a look, if you have a good case, but then you go to court, you find the witnesses all over the place and they frustrate your work. How do you help in making sure that the investigators are on point with what they bring to you, but also in terms of witness management so that your prosecution process is made easy?
Yes. You know, as we guide, we are also looking out to how do we prove this case. Okay, so we look at the evidence, whether it's the documents that will be involved, or whatever piece of evidence, but also witnesses are critical.
Right.
And before we go to court, we ensure that we have a pre-trial with witnesses to ensure that what law enforcement has brought to us and what a witness is speaking to align.
Okay.
If there's a disconnect, it's either something needs to be corrected here.
Right.
If a witness is insisting that, no, this is not a version of issues, it means that there has to be a reconciliation somewhere. And this is why, in certain instances, you find prosecution withdraw from prosecuting a case. It's not a sign of weakness. It's strength. It's integrity. Discontinuing a case. Right. Or deciding not to go any further with a case because you've discovered something.
Right.
Something has been brought to your attention. Is magnanimity a sign of strength? Because then if you don't, you're exposing government to being sued for malicious prosecutions and forced imprisonment, as it were. I think that's extremely important. Okay. So for us, we make sure that, yes, we've read the dockets, yes, we've read the statements, and we'll listen to the witness. But if we see that things are not aligning, decency, integrity demands that case be discontinued.
Right.
Yes.
DPP, I want you to, you have spoken quite in a number of times about public interest. Yes. Your predecessor once made a statement, and I would like to quote. Sometimes there can be, so the point here was that prosecuting corruption can be a very complicated task.
Yes.
And the statement was, sometimes there can be no evidence, but it is in public interest to prosecute. And sometimes there can be evidence, but it is not in public interest to prosecute. Where do you stand with this particular statement?
Very interesting quote. You know, I like the fact that you've aligned it to corruption.
Right.
Because corruption is a very, very difficult crime.
Right.
To prosecute. And this is why, allow me to deviate briefly here.
Yes.
In the Anti-Corruption Act, there's Section 80, which allows for settlements, where the Director General of the Anti-Corruption Commission can sit with an accused person, his legal representatives, to try and agree for them either to forfeit property or to reach some sort of settlement.
Right.
We've used it in the past. It's been used in the past to good effect.
Right.
The public out there may misconstrue it. The thing is, issues are not usually black and white when it comes to corruption. Okay. Because by its very nature, corruption is a secret. It's not something that is done publicly.
Right.
You know, it's rarely do you get cases where people are caught in the act, you know. Right. And this is why you find most of the cases that go to court being prosecuted for corruption will be cases like failure to follow procedure. Right. Because then you have this rubric of what should be followed. Say, for example, in procurement. Right. What a procurement committee should do. And maybe they did not follow that procedure. It's very, very easy, you know. But you will not be there when money is changing hands, when bribes are being exchanged. Right. That secretive act is very difficult to even prove it. So it's not a very easy crime to prosecute because of its, like I said, secretive nature. Right. Yeah. So sometimes it's in public interest to resolve these matters another way. Right. You know. That's why I made reference to Section 80. You know.
DPP, sorry to cut you short. We will talk about specific cases where the prosecution takes off, or you use alternative means of trying to, recover what was stolen. Yeah. And we will talk to that. But I wanted to hear from you. Mm-hmm. Does your office prosecute where there is no evidence because there is public interest? And public interest means the whole country, social media, everyone is talking about someone by perception that this one has done something corrupt and so on and so forth. Maybe they've bought a property and there's noise all over the place, driving an expensive car, and everyone is talking. And then you move in and there's no evidence, but you take the matter to court.
It will be very difficult for me to take a matter to court without evidence.
Right.
I cannot be convinced that a matter should be taken to court where there's evidence. It's near impossible to convince me.
Right.
One of the things that we've done is put in place a prosecutor's manual. It existed, we brushed it, modernized it, padded it up. Right. It's been vetted by legal minds. We also shared it with some judges to look through.
Right.
So that we have a very good prosecutor's manual. We use it to train our interns. We use it for orientation, the people that we are recruiting. That manual guides us and the steps we should follow before we can take a matter to court. Right. And that prosecutor's manual, we've now made it a public document.
Okay.
It graces our website.
Okay.
And we want the public to know, how do we make these decisions, charging decisions, ultimately to decide to take a matter to court.
Right.
We will not take a matter to court where there's no evidence. Especially I as DPP. I cannot be convinced by any of my officers that let's go to court.
There's too much noise on this case, DPP. Let's go, let's proceed.
It cannot happen.
We need to calm the people down. Let them see that we're doing something at least.
It cannot happen. However,
what do you in such circumstances?
Yes, you see, however, we have to learn how to talk with law enforcement and also how to engage various stakeholders, but also more especially the victims. Because you see, even corruption is not a victimless crime. There's always a victim to any crime.
Of course.
And we must engage.
Right.
But what we cannot do is take a matter to court without evidence.
Right.
And when we realize during the prosecution that actually what we thought was evidence is nothing.
Right.
It will not, stand up to court scrutiny. At that point, I'll make a decision and pull that case out of court.
Right.
So we will not take a matter to court without evidence. If you look at our prosecutor's manual, I talked about the evidential test. Right. There must be evidence, but also it must be in public interest. We've also added a third one, the threshold test. Okay. We may not have all the information, but a law enforcement agency assures us that this information will come.
Okay.
We are able to charge that case and take it to court. If that information or that piece of evidence does not come, it means we have to terminate those proceedings.
Okay.
But that has to be lightly indulged in.
Okay.
Because you're talking about liberty and rights of individuals here.
Right.
We rarely use the threshold test. We base it on the evidential test and the public interest test.
Right.
And we will not take a matter to court without.
What about the opposite? This statement is two-pronged.
Yes.
The other side is there is evidence.
Yes.
But there is no public interest in that regard. And there's people are not even aware that there is something like, but it has been brought to your attention. There's even evidence here, but you don't want to,
yes. And there are so many of such cases.
Right.
And we simply, see, it's like you find a 90-year-old man with a dagger in his pocket.
There's evidence there.
There's evidence. He had a dagger in his pocket.
What do you do? He's a senior citizen.
And beyond a certain threshold, he's trafficking.
Of course.
I have to ask myself, of what use is it to take this matter? This is just a rough example.
Right. Exactly. Very good example. The man is 90 years.
Yes. Or the man is riddled with illness, is on his deathbed. But we have evidence that he did this thing.
Right.
of what use is there prosecuting a case like that?
Right.
Or in certain borderline cases, you have someone who's a student, they are young, what they did was informed more about lack of better judgment. When you look at the case, there are no aggravating factors, and you think that they will have a better shot at the future.
Right.
You know, if we took an alternative course. Yes, we have the evidence, but it would not be in the public interest to prosecute someone.
Right.
You do not want the majority of your young population with criminal records. You know, so you want a situation where you are able to make wise decisions as you go on. The public out there may think that we are sitting there waiting to to ensure that people go to jail. No, that's not the case.
Right.
That's not the case.
I don't admire your job then, DPP, because it's a very difficult job, because you to draw the line between how do I make a decision here? It means sometimes people's lives, people's futures are pretty much in your hands. You have to make how hard is it to determine public interest for you when you sit as DPP in your own time, quiet time, and you're looking at the kind of decisions that you have to make? And how hard is it?
It's not an easy undertaking, you know, to make certain decisions that will impact families, will impact the fortunes of an individual.
Right.
It will have adverse fortunes against that individual. It's not easy. And so you don't take it lightly.
Right.
So, as a director of public prosecutions, you have to ensure that you have a very good team around you.
Right.
Extremely good team.
Right.
But not just a good team. A team that you believe in, that they have sufficient integrity, that they'll tell you the truth. Right. That, to me, is extremely important, because these decisions are not made by me alone.
Right.
I listen to the team, what they think. Ultimately, I have to make a decision.
Right.
But I trust the minds that surround me. And because of that, we've been reforming the DPP's office. Right. Just within my office, creating another directory that can directly advise my office.
Okay.
As I concentrate on other things. I have 2 deputies. And then I have deputy chief state advocates. I believe in and this is why you see recently, 4 of them are going to the bench. That talks about quality.
Right.
Quality that is latent within the institution. And so you must ensure that there's a good team, but integrity is key. That you believe in their integrity. And you believe that whatever feedback or proposals they're advancing are not laced with ill motives.
Right.
But that they mean well, they've looked at the issue, but it's not an easy undertaking.
I can imagine that.
Because one thing that you cannot do when you sit in the position that I sit is you cannot pollute the office. You cannot pollute the decisions that you take. You cannot desecrate. You must be sure that the decisions that you are making are backed by evidence and that there's public interest in it. You cannot make this decision lightly or founded on any other ill motive.
Right.
That does not mean you're not going to make mistakes. You will make mistakes.
Right.
But when you make a mistake, you must quickly correct it.
Right.
And this is why you find a director of public prosecutions can terminate a case before judgment. It doesn't matter. It may have been in court for 2 years, 3 years. When you realize that there's something missing before judgment, you can take remedial measures.
Right. DPP, we've seen sometimes where you've decided not to prosecute someone who is an offender because you are trying to use them as a witness to target a bigger fish. How does that work?
Yes. Yeah. So, yes, there's that leverage.
Okay.
You see? Because you'll be looking at a case and you'll be seeing that there's this individual who, though involved, but they have this awareness and the knowledge of what went on.
Okay.
They were not too involved, but they have information which is essential to us securing conviction or helping the court to reach a just decision. And sometimes this is how matters to do with corruption work.
Okay.
It will be, because of the secretive nature of this issue, it will be someone that was somehow involved, someone who somehow has information that could tie some loose ends and join the dots. So such a person would be better utilized as a state witness
Okay.
to aid the state's case, because it will be in public interest to ensure that that case is prosecuted and the conviction secured.
Right.
And overally, you want a court to have full information. So when you have a witness like that, who's going to bring something useful to the court to consider,
Okay.
you weigh the options. You know, you will not get an individual that was actually the instigator and the mover as a state witness.
Right.
You weigh. There are a lot of consideration that are taken
Okay.
in weighing who can be used here to testify for the state.
Right.
Indeed.
It's a very, very difficult job, like I earlier said. I wanted you to speak now to some arrests which we call high-profile arrests that sometimes involve leaders of the opposition. Yes. The public perception sometimes is that, you know, these are targeted arrests. You know, it's a matter that you can let go, but you proceed. They proceed the arrest, and then they bring to your attention. How do you manage those which look really frivolous? Maybe it's just a statement someone has made on either on social media or as they're addressing their supporters. They've just made a statement which is a little bit of too critical to the head of state, for example. And in the interest of freedom of expression, someone would expect that you'd let it lie. But you find someone is arrested and then it's brought to your attention. Do you have moments where you actually say, even if there is an arrest here and this matter has been brought to my attention, I will not proceed?
Yes, I've done that severally.
Okay.
Several occasions. The only difference is that the public will not know.
Okay.
Because a docket will come.
Right.
And we advise law enforcement.
Right.
This matter is not in public interest. To prosecute, you close the file. And we're not taking it to court.
Right. And I was actually going to ask that because most of the times we see them die natural death or they just drag until the public is no longer interested.
Yes. But there are those matters which are brought to my attention, and the docket is brought to my office by law enforcement, that we cannot ignore. And the reason that we cannot ignore is because of the seriousness of the matter.
Okay.
Out there, it may look like it's a trivial matter, but we are looking at, there are certain considerations. For example, national unity, national cohesiveness. There are certain pronouncements that someone makes that ultimately can affect the national cohesiveness and unity of a nation. And that can make certain people feel alienated and question whether they do belong to this enterprise called Zambia. And because law enforcement has not ignored that aspect or the crime that has been committed, when it comes to us, we look at the evidence that's available, we look at the public interest. And we don't, again, make those decisions lightly. We decide to charge. You see, you cannot be in Israel, in Tel Aviv, or in Jerusalem, and begin to extol, under the guise of freedom of speech, the virtues of Nazi Party and Hitler, and leave to face the next day. Why can't you do that? It's because the people there have lived, they know what it means to pay with your life for simply being who you are. They have that history. They will not allow you, under the guise of freedom of speech, to do that. The same way you cannot be in Rwanda and extol extremism of one group of people and live to see the next day. And this is why, informed by the history of just these two examples I've given, I can give Kenya, for example. Kenya, the violence that ensued after the 2008 elections.
2008, yes.
A lot of people died. Over 1,000 people died.
Yes.
And it's in the aftermath of that that they came up with one of the best constitutions we have on the continent.
Right.
But also, they came up with a body to deal with national cohesion and unity, informed by the history. And usually, most of these conflicts and the national disintegration is usually sparked by careless speech.
Right.
Almost in all instances.
Right.
You know, but then also, it's pointed towards pointing out differences between people, tribes, groups of people, raising discontent. Now, any DPP worth its salt on the continent of Africa,
right.
the Western world works differently.
Right.
Okay. But they have issues that they consider extremely important.
Right.
For example, hate speech against people who are differently oriented. Those are serious issues when it comes, say, to the Western world. Just to give an example. When you're talking about Africa, we have our own realities. You cannot wake up and say anything, and then we use the blanket term of freedom of speech, and everyone should be quiet.
Right.
Our realities are completely different from the Western world.
Right.
And I keep telling our Western friends, we operate differently here.
Okay.
You cannot, Mr. Mwenda, call your father Joe. I'm from work, Joe. How are you, Joe? You wake up in hospital.
Right.
You can do that in the Western world. You can even pat your dad in his bald head. Say, Peter, how was your day? You can do that in Africa.
Right.
Because our realities are different. Not that I'm advocating violence.
Right.
I'm simply saying we must. Why did our national founding fathers emphasize national unity?
Right.
Why did they do that? They are the history coming from colonialism, where a lot of investment was made in separating people.
Right.
One group fighting the other. This is how the colonialists managed to rule.
Right.
So they knew that you cannot allow that trajectory to continue. Otherwise, you will not run this country.
Right.
That's why there was emphasis on national unity. And I can give examples from the north of Africa to South Africa. For example, apartheid. Why were decisions arising out of Odessa when they had their conference on coming up with a constitution, and also going the route of Truth and Reconciliation Commission?
Right.
And why they did away with the death penalty?
Right.
Why did they take those decisions? Because you have to go back to the history of that country.
Right.
Why did Mandela, Walter Sisulu, Oliver Tambo, Govan Mbeki, why did they take that route? It's informed by the history of that nation.
Right.
So it's this backdrop that we must understand, that you cannot just wake up and stand and pass a remark that may be viewed to be nothing, that may be too simplistic.
Right.
Because if you dehumanize people, okay, and you make people be hated by other people groups, any law enforcement worth its salt must look at that issue, must bring it to my attention, and must consider it. Now, more often than not, if it's petty, we'll not prosecute.
Right.
If we see something there, we'll take it to court, let the court decide.
Right.
The reason is simple. Sometimes, how do you curb certain vices from growing in a society? You must set an example.
Right.
You set an example. It's not a chill on freedom of speech. You must set an example to people that you cannot talk anyhow. Freedom of speech does not mean you can simply open your mouth and talk anyhow. You can't. You can't do that.
Right. Yeah, but DPP, this particular president has been regarded to be one who has, done what his predecessors were unable to do. For example, he's removed the defamation of the president law.
Yes.
And he was credited for that, and a lot of people were happy. Ourselves as journalists as well, we felt that was a very positive move because there were so many statements which were brought under the umbrella of defamation of the president.
Yes.
But we've removed that law.
Yes.
In the spirit of encouraging, a level of freedom of expression. How do we reconcile? In one hand, we are, outlawing some of these provisions, but on the other hand, we are quite tough on freedom of expression.
Yes. From my standpoint, anything that would tend to denigrating people and affecting the unity and cohesion of this government and the state, the nation, has to be looked into.
Okay.
We have to look at that. There are a lot of things which people say.
Right.
And I cannot repeat some of the things that people say when I'm reading these dockets.
Right.
Some of them are simply, look, we can't go to court over this.
Right.
Some of them may appear serious because of what is said, but there's certain speech which you want the court to have a say on it.
Right.
And speaking like this, I must say that look, when I was in private practice, I took up a lot of cases defending journalists.
Right.
I used to act for Mr. Zambia and had a lot of clients who were journalists. I went to court defending their right.
Right.
Freedom of expression, freedom of the media.
Right. But now you sit on the other side.
I sit on the other side. But when I look, there's been I don't know whether to call it a transformation. The speeches have become more incendiary.
Okay.
And they tend to potentially affecting the cohesiveness and unity of the nation.
Okay.
That we cannot ignore.
Right. DPP, it's not only about speech. And this period that we are going into towards the elections, really the spotlight is going to be on the law enforcement agencies and, of course, your office. Sometimes it's a matter to do with the Public Order Act. People are just trying to meet. You expect, really, we are going to be having elections in August. You expect a political leader to just converge with his supporters or her supporters and talk to them.
Exactly.
And I hope to sit down with the Inspector General of Police soon so that we can understand from his perspective. Yes. But at the end of the day, sometimes these people are picked up and they are charged and the matter is brought to your attention. But you understand that we are in this election fever.
Yes.
Why don't you just let such matters pass?
Exactly. In fact, one of the roles that we play is to also counsel law enforcement.
Okay.
Counsel as in counseling them.
Right.
That, look, you cannot take this case to court, based on the facts that you've brought. We are a democracy.
Right.
People have a right to assemble. Yes, there are procedures they need to follow. They have a right to assemble.
Right.
They have a right to speak to their supporters. They should be able to be allowed to mobilize. Yes.
Of course.
Yes, indeed.
Of course.
And that's what democracy is about. So when a matter like that is brought to the NPA,
yes,
rarely will you see matters the way you've described them going to court.
Yeah.
Because who would have cancelled the police on what needs to be done.
Right.
But also there's a thin line to be drawn between disorder and order. This is why the Public Order Act exists. Of course, we know it dates back from colonial times.
Of course.
The colonialists did not want the African people to assemble and organize. So that law needed to come into place. It was to control.
Right.
It's not just the Public Order Act that people talk about. Even the Witchcraft Act.
Of course.
All these were legal instruments put in place to control the native.
Right.
Because it was felt they could tend to be disorderly. So you needed a piece of legislation that could be used to curb the activities that would arise.
Right.
But we're now talking about the period where we are in 2026. We are able to see when a docket is brought that there's no offense here. And also counsel law enforcement that perhaps go about it this other way instead of this way. Because clearly, certain matters taken to court, you cannot succeed.
Of course.
Yes.
Right. I also want you to now take back this conversation into your office where you need to make a decision to appeal certain matters where you have lost in court because the court felt that maybe you lacked evidence or your prosecutors did not do a very good job, and now you have to appeal or not appeal and let the matter slide. There are certain cases which, when we see in court, we think that if the state is going to lose, immediately there's going to be an appeal. Then we see silence. What informs your decision to appeal certain matters?
Yes. It's on two levels. When there's a clear misapprehension of the law by a court, we will appeal. Because we want a superior court to guide, to have a say on that matter. Because clearly, there's, in our contemplation and in our estimation, it's very clear that the lower court, for whatever reason, got it wrong. Okay, completely misapprehended that aspect of the law. We will definitely appeal. But also, there's a part where we can even appeal a finding of fact that was made by a court. Because even a finding of fact becomes a question of law.
And I want you to speak to my followers when you say a finding of fact. Are you referring to what maybe a witness has said in court during trial? What is that, educator?
Yes, but what ultimately the court finds as a fact. A finding of fact.
Right, during trial.
During trial.
Right.
But if that fact is not supported by evidence, it becomes a question of law. And there are so many precedents. The Kasote case, 1977, that was settled by the court. That misapprehension becomes a question of law on which we appeal. So yes, there are clear instances where the court, when it comes to an aspect of the law, does not get it right. You know, I'm trying to choose my words very carefully when talking about the courts.
Of course, I can understand. Yes.
But also on this other side, where there's a problem with certain findings of fact, we're not backed up by evidence. They become question of law. So my office has been appealing those instances, just to simplify it for your audience. We do appeal, and the reason is not because we are unhappy that there's a certain decision made, but because we feel a superior court must have a say that this decision made is a safe decision that we can rely on in the future. This is how we grow our law and ensure that these precedents are ones that can be followed and respected in future. This is why we appeal.
Right. And also, I would imagine that it's also the reason why you decide not to appeal, when you can clearly see that,
we will see that, look, perhaps the court got it right in this case. We overlooked this issue, the court got it right. And in the National Prosecution Authority, we have a dedicated department of appeals. We call it General and Appeals. So they deal with appeals and all general matters. Like, you know, when our employees sue us, we have matters that may not be strictly criminal, but because we are a legal body as National Prosecution Authority, they handle those. But the bulk of the work they do are issues to do with appeals, issues to do with bail. Yes. So we have a specialist unit that specializes just in this aspect that you asked me.
There's a famous expression or a legal term that a lot of Zambians know, but they don't know what it means. My colleagues who are watching wonder, what is the Nolle prosecute, and how do you use it when you are trying to withdraw these cases, or we're trying to discontinue a case? And while you are answering that, earlier I said that I consider you one of the most influential people in the justice system, because you all pretty much almost know an explanation in some of these decisions.
Yes.
How do you use a Nolle to make sure that you don't abuse it?
Yeah, that's extremely important. You know, Nolle prosequi can easily be abused. You know, and this is why you have to execute your duties as a DPP with a lot of humility, and you have to ensure that, like I said earlier on, you have a good team, because almost all these decisions, yes, I ultimately make the decisions as DPP. And in the past, I had noticed that there's a little bit, you know, our prosecutors, our state advocates could issue nolles. But now we've brought structure.
Okay.
And the issuance of a nolle, which leads to discontinuing a case, has to be authorized by my office.
Okay.
And within my office, as DPP,
Right.
yes, we have this elaborate structure, but directly within my office,
Right.
there's a subset structure
Okay.
that is able to quickly look at some of these issues and advise that, yes, it's needful for us, we can enter a nolle in this case. Right. And there's always, when a nolle prosequi is entered, which simply brings a matter to a halt and ends proceedings. First of all, it's not an application before court.
Okay.
It's not an application. It's the DPP has made up its mind, and once it's brought to the attention of the court, everything halts.
Right.
The court cannot, in fact, even inquire and decide to reject it or not. No.
Right.
Right there and then. It's a nuclear bomb.
Exactly.
Everything ends. And this is why.
On a light note, remind me of the case of former DPP Mtembo Nchito, whose removal was very unceremonious. And while he's still serving as DPP, they arrested him and, threw him in police house, and he entered Nolle. You are very close to that case yourself. Yes. I don't know what comes to your mind when you think about that and the power that you have yourself as DPP now.
Yes, you see that power.
You can execute that power.
Yes, that power. Once a DPP issues a nolle, it does not matter the circumstances.
Right.
The court knows right there and then the court is shackled. There's nothing the court can do. In the case that you've given, the example you've given, the magistrate there,
hands tied.
Despite the protestations, he was very categorical that we all know what the law
the law
says about it.
Right.
And it's in the Constitution. It's a power that is donated to the DPP by the Constitution, by the people.
Right.
And it cannot be questioned.
Right.
And the DPP does not need to even explain the decision. Why? Right. Because there are a lot of considerations.
Right.
Because I've heard people, there's a school of thought that says the DPP should be able to explain.
To explain the
why he has entered the nolle.
Right.
But you then need to give a certain level of immunity to the DPP, just regarding that, to explain.
Right.
Because in the DPP explaining why he has entered the nolle, a lot of lives may be ruined in the process.
Right.
Because the DPP will enter a nolle, and a few days restart the matter before a different court.
I see.
And the matter proceeds incident-free.
Okay.
What do you want the DPP to explain? If you are dissenting, why do you want him to explain?
Transparency.
Yeah, but it's a facility that is well thought out, that also aids the criminal justice sector to move in a certain way.
Right.
Other than without it, there'll be serious impediments. Because sometimes it's very clear. This case going nowhere. Right. There's no evidence. Why should we proceed with this case? We might as well end it now.
Right.
There's no any other better device or facility that has yet been invented that would replace a nolle in certain defined circumstances.
I want now to take you back to your success record. How does it look like in terms of cases that you have succeeded to secure convictions?
We've done very well in this arena. In 2025, we recorded 1,465 convictions in the High Court against 2,091 cases that were cause listed.
Right.
So convictions were 1,465 and only 61 acquittals.
Okay.
In the subordinate court, the magistrate court, we recorded 28,965 convictions against 44,810 matters that we took to court, or in other words, cause listed.
Okay.
And in terms of acquittals, we had 1,478 acquittals. So you can see the convictions were phenomenal, and very, very few acquittals. And so many cases taken to court, of course. Underscoring the point that I was making, that a lot of investment is being made in fine-tuning the skills of our prosecutors and investigators.
Right.
And we are working more collaboratively, and not so much in silos.
Okay.
So the successes of prosecution are the successes of investigation.
Okay.
And because of that, we've been able to score these successes. Again, it explains that we do not dream up these cases and take them to court maliciously. They are informed by good evidence.
Okay.
Yes, there have been failings due to human errors, human mistakes. We've had those situations. This is why we've invested in a lot of training of our prosecutors, and some of the training actually involves law enforcement agencies. Since 2020, end of 2022, we decided to come up with the interagency coordination framework, which brings together about 22 institutions, all law enforcement agencies, regulatory agencies as well. When we have complex cases, we do impanel smaller teams to work together, especially in those cases which are very complex cases. So this issue of working in silos and waiting, writing a letter to one institution and waiting for an answer, we've cut that out. We are able to work together in these complex cases, but also do training together, especially when it comes to financial investigations and prosecutions. But also the coming in of the Economic and Financial Crimes Court, where cases should take 5 months to be concluded, and where now working like civil cases, where the accused must be given all the information, including the evidence, the list of witnesses, the documents you are going to rely on, you give, you know. So it's front-loaded. You give them in advance. It means that you better have proper skills to prosecute that case. We were not used to that. Prosecution used to be by ambush, especially in the subordinate court. So these advancements that we have seen entail that investigators and prosecutors be well trained. Yes. So we've invested a lot of training in our prosecutors and our investigators. This is why you see every year we have the National Annual Prosecutors Conference. It's the biggest capacity building forum. And we invite investigators to that forum. And we are looking at advancement in some of the crimes that away from the traditional crimes of homicide, aggravated robbery, because we are trying to get ahead. Yeah, so we've invested in a lot of training to ensure that we improve the cases we take to court, which has resulted in a good percentage increase in convictions. Yes, and some, like I said, we withdraw them. Some, rightly so, people are acquitted.
DPP, I want you to talk to us about the non-conviction-based forfeiture of assets. Why is it that sometimes people are prosecuted, sometimes you just go for their assets? And for us, the members of the public, we don't see a very big distinction in those, some of these cases. What informs that decision, whether to just, recover the assets and let somebody go scot-free, or you would want them to be prosecuted and sent to prison?
Indeed. I think non-conviction-based forfeiture is quite distinct from prosecution, where someone ends up going to jail. When it comes to non-conviction-based forfeiture, first the background was, it became very clear within the criminal justice sector that it was not all the cases where you would succeed to secure a conviction, because the threshold is quite higher, beyond reasonable doubt. It's not in all the cases that you're going to secure a conviction. And when people are acquitted, they would get away with it. Hence this innovation. Now, this innovation was done at an international level. And countries legislated and ensured that non-conviction-based forfeiture became part of their legal regime. And when we talk about non-conviction-based forfeiture, we're talking about the DPP suing the property, not the individual. It's not the individual. it's the property that you go for.
Right.
That's why if you see even the way the cases are named, it will be the DPP versus maybe a property and vehicles and so on and so forth.
Okay.
Yes.
Okay.
Because it's a property that you go for.
Okay.
And why are you going for that property? Because it's a tainted property.
Okay.
Now, the rights of the individual that is affected, those rights are respected by the court. This is why a safeguard is the Director of Public Prosecution must bring to the notice of any individual directly affected or who might be affected as a result of that action which has been brought before court for non-conviction based forfeiture. Without that notice, the court will either dismiss the application or will ensure that it gives an order to allow for you to save an interested party.
Right.
So there's fairness in the process. But the aspect of notice is critical. The person affected must be notified.
Right.
The reason is to allow them to join the action and be able to explain or contest the decision.
Right.
Now,
So it's bait. You're trying to lure whoever is behind the assets now to come and defend the problem.
yes, but it's a civil action now.
Right. Okay.
It's not like a criminal action. So in that case, you go for the property. The person comes and they will be able to explain. But also, even before you get to court,
Right.
you see, these matters before they reach court, law enforcement agencies would have done some investigation.
Okay.
They will be interviewing people. Explain to us, how did you acquire this property? You know, it should be very, very simple, for example, for you, Mr. Mwenda, to explain how you managed to buy this set of equipment that I have here.
Yes. I want to be very clear because these are cases where sometimes people feel you are very selective. Some people, you know, are not taken to court. Some people are taken to court. What informs that decision in the office of the Director of Public Prosecution, sitting with the other prosecutors in the National Prosecution Authority?
Yes. We are at the beck and call of law enforcement agencies. They bring dockets to us, even for non-conviction based forfeiture.
Okay.
So we'll get dockets from Drug Enforcement Commission, Police, Department of National Park, Forestry, and we'll assess and decide to take to court.
Right.
If we have not taken a matter to court, it's either because we've not received a docket from a law enforcement agency, or we've adjudged that the interested party's explanation was a credible explanation. Because what the people of Zambia need to know is a reasonable explanation suffices.
Okay.
Now, the lawyers tell their clients, stay silent, don't say anything. Now, on the strength of that, if, for example, I bought a Lamborghini and, you know...
And we know your income.
Yes, you know my income as a civil servant. Or I have an emerald mine.
Right.
You know?
Yes.
I can explain.
Right.
I can show you. I sold my emeralds in India and Abu Dhabi, and I paid tax.
Right.
I managed to buy this machine.
Right.
There shouldn't be a problem with offering that explanation.
Right.
The problem is when I'm unable to give a reasonable explanation,
Right.
which may be backed by evidence, but it's not everything that you should produce all the receipts of properties you bought 5 years ago.
Right.
Many of us cannot do that.
Right.
But there's a reasonable explanation. He works in a bank. He has access to loans.
Right.
He gets a gratuity. He can afford to build this house. He can afford to have a farm, to have cattle, to have these vehicles, to send his kids. Now, if you work in the National Prosecution Authority, in the registry, and you drive a Lamborghini, and you send your kids to International School of Lusaka, and no law enforcement is asking questions, we have a problem there.
Right.
We have a big problem. So, yes, a reasonable explanation is going to suffice.
Right.
And you know, right at that stage, at investigation stage, a case will be dropped.
Okay.
Now, how do these dockets even manage to reach my office? It's because law enforcement is not satisfied. When it comes to National Prosecution Authority, we are also not satisfied because even at that stage, we are still able to engage with lawyers.
Right.
In the past, we've been able to engage and reach a decision.
Right.
In certain instances, in borderline instances, allowed individuals that the state will get this. You will remain with that. We are not convinced about this.
Right.
These settlements are allowed under the law.
Right.
So a reasonable explanation suffices. So to answer your question directly, people actually clearly misunderstand and they are misled by people that try to purport that there's a selectiveness in the way we take these matters to court.
Right.
It's informed by what we see on the docket, the information that we have when we compare the two. And this is why our success record is very high when it comes to non-conviction based forfeitures.
Okay.
Yes.
I was going to ask you about that record actually, that how have you performed? Because
we performed very, very well.
Okay.
When it comes to non-conviction records, since August 2021 to date, in terms of kwacha alone,
right,
our recoveries are 43 million kwacha.
Oh, wow.
And this is just kwacha, cash amounts.
Right.
United States dollars, 41 million United States dollars.
Right. Separate amount.
Separate amounts.
Okay.
And of course, you would have smaller currencies or small amounts in currencies, say rupee, rand. But here we're just using the United States dollars, 41 million.
Okay.
Now, Samanda, this is unprecedented in the history of this country since records began.
Right.
The fight against corruption between 2021 and to date is unprecedented.
Okay.
It has no equal.
Okay.
Yes, it has no equal. And I've just talked about money. I'll give you figures for real estate properties. 130 properties. And these include houses, flats, farms. 130.
Okay.
Aside the monies we talked about. In terms of motor vehicles, 230. This includes aircraft, by the way. I know you only know two, but there are many more.
Two are the most famous ones.
Yes. And then we have other items.
Okay.
So, for example, 4,000 individual assets. These would be like bicycles, timber, minerals. 4,000. Okay. And then bulk commodities. We have 10,000 of gold bars, manganese, quartz, copper, cash I've already mentioned.
Right.
But this has been a sustained. Forget about convictions. We've secured a lot of convictions. They are all in public realm.
Right.
This, I'm talking about a short period of 5 years. In fact, we can even shorten this period further.
Right.
All this largely achieved in the last 3 years.
Okay.
Largely. Now compare this, and the comparisons are not to denigrate or to diminish what was done. The fight against corruption, when you're the task force against corruption,
right,
it ran for 8 years.
Right.
The net recoveries, $15 million US.
Okay.
8 years. The beneficiaries were lawyers, mostly foreign lawyers in legal fees. The gross was about 30 million. Okay. In 3 years, the statistics I've given you. Right. This has been the most sustained, the most successful fight against corruption. But it has not just been a fight. We also have managed to put legislation in place.
Okay.
This is why we have the Economic and Financial Crimes Court.
Right.
To ensure that we undergird this for the future.
Okay.
But also launched the policy on anti-corruption, national policy on anti-corruption. These are important issues.
Right.
Internally, even as National Prosecution Authority, we have an asset forfeiture department.
Okay.
We have now set up the Wildlife and Environmental Crime Department.
Right.
We also have the Economic Financial Crimes Division within the NPA. So you can see the results.
Right. But there's a line of thought, TPP, that...
you can see the results.
Right. But there's a line of thought, TPP, that you're actually only contributing to the cycle of crimes because those owners of those assets, they don't feel the pinch. I would like to believe that when somebody bought a Lamborghini without justifiable income that can correspond to such a purchase, obviously in the state grabbing that asset, there's a conviction that this person committed a crime. And you have taken the asset. Yes. But that person will commit another crime because they've just lost the asset.
Yes. Now, We usually do both, side by side.
Okay.
I can give examples. It's just that some cases are in court.
Of course.
Yeah. Where we've secured the conviction on the one hand, and also ensured that the properties were forfeited
Okay.
at the same time.
Right.
There's nothing that stops this dual arrangement at the same time being executed. Non-conviction based and prosecution, criminal prosecution.
Okay.
We've done both in certain instances.
I see.
Yeah, some matters are on appeal, but famous individuals that are sitting in jail have had their assets forfeited to the state.
Right.
Yes.
And when the UPND came into office, one of the things they did was to call for people who know they may have committed crimes by grabbing property which they can't justify, to just show up.
Yes. Exactly.
And report themselves.
Exactly.
I found that to be very strange. A thief can come and tell you what I stole. Please don't arrest me, just take my property.
Because this has been tried and tested before in some jurisdictions.
Okay.
And some people, because they are afforded that anonymity, and they've come forward and surrendered massive properties.
Okay.
An example is Angola.
Okay.
Angola has had more recoveries, I think, on the continent of Africa. They're only second to Nigeria. Because they were given that window.
Okay.
The people that were willing to come forward. And I'm talking about massive assets that have been surrendered. Because people realize that once that window closed, the sanction regime that followed was deadly.
Right.
You've seen what's happening in Angola. The daughter, the former president, has had to leave jurisdiction, has $1 million frozen just in Abu Dhabi. Banks seized in Spain. That is after this window closed. Right. But this is one aspect we've actually gone to benchmark and observed in Angola. I've been to Angola myself
I see.
with other heads of units, law enforcement in Zambia. Right. And we've been able to see the scale of assets, infrastructure that has been surrendered to the government.
I believe it's also a bit cheaper.
It's cheaper
for you because you don't waste too much time.
You don't waste judicial resources, prosecutorial resources, investigative resources. You don't waste. Right. But the individual, of course, remains with something.
Right. And I wanted to ask that, because what about either I remain with something or I don't even tell you some of the stuff that I got illegally. What happens?
That's the thing. The example of Angola is a good example. Vicente Emanuele, the vice president of Angola. Right. Some of the things he was able to give up, and he's not being prosecuted. And many others are generals in the army. Some of the buildings that have been forfeited in Angola, hotels, massive infrastructure. You can't equal any building in Zambia. Some of those. Because we went to do a practical benchmarking exercise. Right. Hospitals, schools. I stayed in one hotel which has been forfeited voluntarily. And had lunch in another hotel forfeited in Angola voluntarily. Now, these are massive. There's nothing comparable in Zambia. Right. Now, if they went to court, they will still be talking. It will still be, the matters will be on appeal. They'll still be fighting. So, yes, there was that in your question. I think that was a very, very good alternative to pursue. But you have to afford people that anonymity. And that, look, yes, if you take this route, these things will not apply. This is why the Truth Reconciliation Commission in South Africa worked well, because people that came up voluntarily knew that there would be some sort of amnesty if the truth came out. The same with Gacaca system in Rwanda, post-genocide, where they allowed the communities, to resolve using the traditional mechanisms. By the way, which traditional mechanisms of dispute resolution are allowed in our constitution, I think Article 118. So that was a good way to go. But of course, if people don't take the bait and come forward, we have to resort to what is happening now, which is unfortunate.
Right. When we talk about, non-conviction based forfeiture of assets, there's an elephant in the room that is very difficult to avoid. It might appear that your office and that of law enforcement agencies is targeting the Rungu family. Why are you targeting the Rungu family? Even when the man has left us. Without reference to any specific case, why is there this feeling that the Rungu family is in it, you know?
Yeah, it may appear like that. But these cases have been running since 2021.
Okay.
And unfortunately, they are still running even after the death of Dr. Edgar Lungu, may so rest in peace.
Right.
So it's not like these cases started now.
Right.
They've been in court. And of course, the state has succeeded at the High Court level, and there have been appeals.
Okay.
And because the family is appealing, of course, the matters have to continue in court. Yes.
Can you assure the people that as DPP, there is no such instruction where you are told to say, please make sure this family, they made me suffer, these people. Can you assure the people that you are not acting on any kind of instruction?
No, not at all.
Okay.
Not at all. And you know, this is a thing.
Because earlier we talked about public interest.
Yes, public interest.
There is no public interest, but you are pushing this direction. And maybe there is public interest and you are just doing without evidence.
Yeah, this is the interesting part. And you know, it would be very difficult for you to believe this.
Right.
I have never had such a conversation
Right.
with the appointing authority.
Okay.
Nail someone or do this. And I think that I've always wondered why that is the case.
Okay.
You know, he will never instigate and call you and say, make sure.
Right.
No such conversation. Of course, he's a member of the public as well, like every other Zambian who will be concerned if action is not being taken. But he does not issue this type of instructions to the office of the DPP.
Right.
These actions that are taken are informed by the evidence that is on the docket when it comes from law enforcement.
Right.
There are many other cases we've had to send back.
Okay.
Much more enlightened now that they know they cannot do certain things.
Right.
That there are certain boundaries that cannot be crossed.
Okay.
But that does not mean that I cannot sit with you, Mr. Mwenda, and listen to your views. How come you're not doing that?
Right.
That does not mean you're instructing me what to do.
Right.
But you have a right as a citizen. This is why we're engaging the public more now.
Right.
And this is why I'm sure you've never had a DPP sitting in office come on a podcast to discuss.
Of course, and I'm honored.
And you know why we do this is we want to engage the public. We want to demystify our office.
Right.
The public should know that they can engage my office. They may have a complaint, for example, against corruption.
Right.
Against my prosecutor.
Right.
Or something that has gone wrong. They are free to either write, to either phone in, or seek an appointment either with me or any of my senior officials.
Right.
To ventilate. We keep demystifying this office. We want to ensure that the public knows
Right.
that we are servants. You know, I'm a director of the public. Public prosecutions.
Right.
The interest of the public is what we take into account. So, yes, we are not told what to do. We know what to do.
Okay.
You know, and we know when there's a case to pursue or there's no case.
Okay. What do you think about the witness protection system in Zambia? I'm asking this because you know, sometimes you can pick up very big cases from someone who might appear not to be a very serious witness, but because they witnessed something or they are aware of certain information. But sometimes they don't feel very comfortable to go to the law enforcement agencies because they don't feel they'll be protected. And sometimes they even rush to ask the media. And they say, hey, there is this matter, can you investigate and publish? But we are not a prosecuting, authority. So in the end, we write a story, it dies there. Because they're afraid to come to you.
Yes, I agree. We can improve our Public Disclosure Act, Whistleblowers Act. We can improve it, no doubt about it.
Okay.
Because there are certain latent weaknesses within. And exactly the issue that you talk about, that protection is missing.
Okay.
Kenya has done very well. Kenya has the law, but not just the law. It has a body that protects witnesses.
Okay.
And that body is able to provide security and provide anonymity, We know that in some of the advanced jurisdictions, they even change the names, relocate.
Right.
You know, they are given different jobs. That's part of witness protection.
Right.
We can copy from our friends and see how do we enhance the protection of witnesses so that then people are very much willing to come out.
Right.
And they are very sure that there will be no reprisals after they come out.
Of course.
You know, because that's the biggest danger. Because people feel, if I come out and I testify, what happens to me?
Right.
So we can improve the law.
Okay.
As it is, yes, it's a useful piece of legislation, but we can improve it further to ensure that people are assured that when I bring out this information, then my family, myself are protected. This is why you see that people come out more when there's change of government.
Right.
Because they are thinking, okay, the DPP is corrupt. Okay? We think he has done something wrong. Right. If we report, he's still in that office.
I'll be in trouble.
I'll be in big trouble.
Yeah.
So we wait for him to leave office.
Right.
So now that's when this fight begins to look selective.
Okay.
It's not that we are cherry picking which cases to take to court or not. The problem is people largely are scared to come out. They may have the information because some of them will be in government service.
Right.
And they are thinking, okay, I have this information. If I come out, what will happen to me?
Right.
So that's a problem that we have.
Okay.
Now, if we have a more robust, updated, and very assuring public disclosure and witness protection act, you are going to see a lot of people coming out.
Right.
Especially if we handle issues of anonymity, issues of protection, and ensuring that families are protected. I think we'll see an improvement.
Right.
We can in fact begin to discuss whether we need the witness protection body, as Kenya has it,
right,
that focuses its mandate on only protecting witnesses,
okay,
you know, and looking after their welfare while a matter is in court, and after the matter, they are even escorted to court.
Okay.
Yes.
Right.
So the welfare of those witnesses is well taken care of.
Right.
That may aid in the fight against corruption.
DPP, as we come towards the end of this interview, I want us to discuss the recovery of assets in foreign jurisdictions.
Yes.
Earlier, when you just assumed office, one of the pronouncements you made was that you were going to be quite aggressive on that, yes, even including those safe havens, which people feel they are very comfortable with, illegal assets being hidden in those offshore accounts. Yes. How much mutual legal assistance have you seen coming through in that pursuit?
Fantastic.
And which jurisdictions have you been working with?
Fantastic. We have worked very well in that field.
Okay.
We've cooperated very well with those jurisdictions which are favored destinations by people that loot this country.
Okay.
Yes, we know certain jurisdictions afford you some level of security, but all nations are subject to a certain regime of vigilance internationally.
Right.
You know, for example, the Financial Action Task Force, FATF, ensures that we are all subservient to a certain regime of anti-money laundering.
Okay.
So, what Zambia has done is to be in discussion, and in most instances, we are almost coming to that position where we'll be entering into mutual legal assistance agreements. Okay. With the jurisdictions of choice. Already, we've formalized that with Hong Kong. We are in discussions with other jurisdictions. I may not name them here.
Right. Okay.
But it's not just outside Africa.
Okay.
Within Africa, we are ensuring that we cooperate more.
Okay.
Zambia sits on the executive committee of the African Prosecutors Association. Zambia is president of the Southern African Heads of Prosecution Forum.
Okay.
Zambia is part of the Eastern African Association of Prosecutors.
Okay.
We are very active in the International Association of Prosecutors. All these associations, whose meetings we attend,
right,
and many other bodies, like the Globe E.
Right.
These interactions enable us to exchange information and to develop relationships with jurisdictions.
Right.
So I can tell you, Mr. Mwenda, if you are going to send money to a jurisdiction X, trust me, I will know. Whether something happens now or doesn't happen, somehow, remember I talked about the interagency.
Right.
Now, that's not to say you shouldn't invest in offshore. When you've worked hard and you want to invest, please do so.
Okay.
But now the world is becoming smaller because we are uniting as jurisdictions.
Right.
And sharing information. And for us, we are ensuring that we plug in as Zambia and cooperate with other institutions. Right. There are other countries that want information from Zambia. We cooperate with them.
Right.
We want information from them. They cooperate with us.
Right.
Others are a work in progress. But I can tell you, working with the World Bank and the United Nations Organization on Drugs and Crime, UNODC,
right,
there's what we call the GIFA series on asset recovery.
Right.
Zambia has been one of the focus countries. In fact, Zambia became the second focus country after Moldova.
Okay.
And what that has done for Zambia is it has allowed us to be able to be at most major international conferences where all the big boys attend. And we've been able to have bilateral meetings and reached bilateral agreements to cooperate in investigations and repatriation as well as prosecution.
Okay.
So we have built very, very good networks. And also we've leveraged from the expertise of international bodies to train our prosecutors and our investigators. Right. So the days when people would get money, this I can tell you, get money and hide it in a jurisdiction, those days, trust me, are almost over.
Right.
They are almost over because of the cooperation that the nations have.
Right.
Unless perhaps you bury it in the sand or you hide it in the ceiling, we may not know for some time. But as long as there's a footprint, you send money, say, to Singapore, I'm just giving an example, and you think law enforcement will not know.
Right.
Why do people think Financial Intelligence Center exists for?
Right.
It's linked to all these other institutions and exchange information.
Right.
The banking system.
Right.
Yes.
I'm glad.
So the fact that we don't stand up and announce, that doesn't mean we don't know these things. We know these things.
Because we have seen that the Financial Intelligence Center is being blocked from inspecting your fraternity, your legal fraternity. When we put money in some lawyer's account and then they keep it for us, it seems to be quite safe there. And there's this whole battle that is going on now with some, the FIC trying to inspect some law firm and the law firm pushing back. And we've seen some interest from the Law Association of Zambia wanting to, to join that case. I don't know without, the risk of contempt. I don't know if you can speak to my wish to hide the money locally with a law firm. Because it seems law firms are also banks now. We can just keep money in the law firm account and then we are safe.
Yeah, that's a problem there. The Director General of the Financial Intelligence Center has the powers. Okay. Has the powers. And is not... Yes, I know the matter is in court. I may not speak directly to them. Right. But if you look at the act that he operates under, he actually has those powers. In fact, every law firm under the FIC Act, you are supposed to have compliance officers who are supposed to, in fact, render reports and to flag any suspicious transaction. Okay. Of course, I know that's what is being challenged in court, and I have my own views on that issue. Right. However, that does not mean the Financial Intelligence Center does not know. Not just the center. The banks themselves have the knowledge of whatever monies are being put in law firms. The knowledge is there, the amounts are known. Right. So it's actually a false sense of comfort to think that you are protected. Okay. Because even the matter which has gone to court will terminate. But it will have to be interpreted according to the law at the end of the day. Right. Yes, I hear the argument. Being a lawyer, we know the law. We know the lawyer-client relationship. It's attended by a lot of characteristics.
Right.
It's a fiduciary relationship. But at the end of the day, the Financial Intelligence Center and the banking system has systems as well.
Okay.
And we are all accountable. You know, they are not acting outside the law.
Right.
So, yes, it may seem that, you know, putting money in a law firm may give you relief, which is temporal. However, that does not mean that is not known.
Right.
And then that does not stop, by the way, a law enforcement agency to seize that money.
I see.
Because there's legislation that allows them to do that.
Right.
And once that money is seized, nothing stops them from investigating and presenting a docket to my office, then to make an application for forfeiture or to proceed to prosecute.
And money there's a bank and then there's a law firm. I would like to believe, and I'm a lay person, I'd like to believe when you're giving money to a law firm, it's for a specific transaction that I hope you are trying to execute, isn't it?
Exactly.
Do you keep money in a law firm
no,
for purposes of safekeeping?
No. In fact, exactly. You've put it very well because you're giving your money to the law firm. The law firm does not offer banking services.
Exactly.
Again, remember, the lawyers are legal practitioners who are bound by the provisions of the Legal Practitioners Act.
Okay. Right.
And they're supposed to be honorable people. Lawyers are supposed to be honorable people.
Right.
And this is why we have a Legal Practitioners Committee that deals with infractions committed by lawyers.
Okay.
So a lawyer does not act in isolation.
Okay.
You know, we subscribe to a certain code, and it's in the law. The same as judges.
Okay.
You know, they also have a judicial code of conduct. So, yes, you have a client's account, you have an office account with a bank.
Right.
Once you do that, that is caught up by the Banking and Financial Act.
Right.
And many other regulations, because the banks also are subservient to the central bank. They are required to undertake certain processes.
Right.
And also there's a reporting mechanism.
Right.
Especially when there are these suspicions and illicit transactions. Right. And that's how the Financial Intelligence Center also comes in. And we have law enforcement agencies. Right. Yeah. So the issue of law firms is, it may seem like a safe place, but it's not really. Right. It's not really safe.
Director of Public Prosecutions, thank you so much for joining us on Mind Your Business. I'm so honored that you made the appointment.
Thank you so much. This was very short, but I'm also honored to have been invited.
Right.
And to speak to hopefully the Zambian people.
Right.
And hopefully we've been of use.
Yes, of course, very much. Well, this has been Mind Your Business. And I have been speaking to the Director of Public Prosecutions, Mr. Gilbert Phiri, State Counsel. Until next time, bye-bye.